Thank you for coming today. I'm attorney Gloria Allred, and with me is Mimi Haley. Yesterday, the New York Court of Appeals reversed the convictions in the criminal case of People versus Weinstein. My client, Mimi Haley, was the key prosecution witness in that case. She testified bravely, and based on her testimony and other evidence, the jury found beyond a reasonable doubt that Harvey Weinstein was guilty of criminal sexual assault of Mimi. Mr. Weinstein was sentenced to 23 years, 20 of which were as a result of his criminal sexual assault on Mimi. Mimi is here today to share her feelings about the reversal and her feelings about what should happen next. She has demonstrated enormous courage by being willing to testify and be cross-examined about a very traumatic experience in her life. I admire her very much for the many sacrifices that she has made in order to win justice. Many people have asked me for my thoughts concerning what should be done under the circumstances in New York to improve and protect victims' rights, and in particular, the ability of, quote, Me Too, end quote, witnesses to be heard in criminal cases. They have also asked me if I think the New York Court of Appeals reversal will have an impact on Mr. Weinstein's conviction in the California criminal case. I do not believe that even though Harvey Weinstein won his appeal in New York, that it will affect the conviction in his criminal case in California. The New York case was decided on the basis of facts in the New York case and also under New York law. The facts and the law applied are different in New York than is true for the facts and law in the California criminal case. The case decided by the New York Court of Appeals is not a binding precedent for our California Court of Appeals and our California Supreme Court. The New York Court of Appeals decided Weinstein's appeal in part on Molyneux witnesses, colloquially called Me Too witnesses. In New York, there is no specific statute, meaning law, concerning the testimony of those witnesses. There is a case called Molyneux, and there is a rule 4.05 of the Guide to New York Evidence. The rule is applied regarding what may be admitted pursuant to this evidence based on the Molyneux case, but there is no statute. In general, the test is whether evidence of prior bad acts or uncharged crimes is more prejudicial than probative. Often prior bad acts and uncharged crimes in sex crime cases are considered in New York more prejudicial than probative in New York. In the California case, there are different facts and different law. In California, we have a specific statute, meaning a law passed by the legislature. Evidence Code 1108 that governs the admission of testimony from prior bad act witnesses. Evidence Code Section 1108 allows courts to admit evidence of uncharged sexual offenses to show a propensity to commit sexual offenses. Of course, it's still within the discretion of the court, the judge, as to whether to admit those witnesses. In general, evidence of prior bad acts and uncharged crimes in sexual assault cases may be admitted more often under the statute if it is considered more probative than prejudicial. In other words, more likely to lead to the truth than be prejudicial to the defendant. I think it's important for the New York legislature to pass a specific statute in New York which more clearly defines the admission of prior bad act witnesses and their testimony in New York and is more protective of victims' rights in sex crime criminal cases. I call on victims' rights advocates and plaintiffs' attorneys to join me in proposing a law in New York that is similar to what we have in California so that victims, as well as defendants, will be able to receive a fair trial. And now I would like to introduce the person I believe is the hero or the shero of the case, and that is my client, Mimi Haley. She will read her statement, and then after she concludes her statement, she will take a few questions. If any member of the press who is listening and viewing this Zoom would like to ask a question, simply go to the chat, go to Q&A, and post your question and who you are, and then we will attempt to answer your question. I will answer some questions as well. And now, Mimi Haley.
Thank you, Gloria, and thanks for coming. I might have to put my, oh dear, what did I do? Oh no. Wait. Sorry. Oh my goodness. I've lost it. I have to find it. Sorry, 1 second. Tap one wrong thing. Okay. I need to put my reading glasses on. Sorry, it's a bit reflective. I feel overturning Harvey Weinstein's conviction was a terrible decision that sends an extremely disheartening message to victims of sexual assault everywhere. We made progress of historic proportion when justice was served, and myself and the other women who testified were truly seen and heard by the judge and jury in this very public case. The verdict undeniably had a ripple effect across the globe, which gave hope and courage to women and men everywhere and set a precedent for similar cases. Yesterday's devastating reversal of this conviction will no doubt also have its ripple effect. As we are witnessing with many events in the world at this time, it's a crucial moment in history to keep going and keep standing up for truth. While this is a setback, it will not undo the leaps forward we have made, and it will never undo the truth. Stepping up and speaking truth to power, stepping out of our comfort zone for the higher good, feeling the fear and doing it anyway, comes with challenges and sometimes sacrifices. As re-traumatizing, exhausting, and terrifying as it was to publicly relive and rehash this crime in a legal process that took 2 years of preparation, I will consider testifying again should there be another trial. While the Molyneux witnesses would not be allowed to testify in a retrial, I'm glad that they too got their day in court, which I feel provided crucial information about the predatory pattern and character of Mr. Weinstein.
Thank you, Mimi.
Thank you.
And now, again, we will be happy to answer a few questions. Just enter the chat and post your question, and we'll be happy to answer it. While we are waiting to see if there are questions in the Q&A section, I will say that this is the first time that Mimi has made a statement and provided her reaction to the New York Court of Appeals decision. And we're glad that she's been willing to make her statement today. Okay, I see there's a post. Okay. The first question is from Rachel Sharp, and it's for me. It says, and she's from Law 360, and she says, "Thank you very much for doing this, Ms. Allred. Have you been in touch with the Manhattan DA's office since yesterday's decision?" I have communicated with someone there, but we have not yet been able to connect on a call. The next question is from Jan Ransom. And her question is, I'm a reporter with the New York Times. Can you tell us if the DA has reached out to you about participating in a new trial? And the answer is no, not yet. The next question is from Sally Hawkins. Do you believe that your case can get another conviction without the prior bad act witnesses? I'll send this to Mimi if she would like to venture a guess, but if she would like not to venture a guess, that's fine as well, because that's really a question I think that the district attorney, the prosecutor, would need to answer. And if they decide to proceed, I'm going to assume that they have made the decision that they might be able to prove their case beyond a reasonable doubt without the testimony of the prior bad act, also known as the two witnesses. All right, go ahead, Mimi.
Yeah, of course. I can just give my opinion on it.
Sure.
To me, it seemed that the jury really took a lot of care to look at all of the evidence very carefully and assess each individual charge. There were three, or well, five with the joint ones. Very, they looked at each one very carefully. And so I believe personally, I mean, the truth doesn't change. The evidence is still there. So I don't see why it would be another result.
Even without the testimony of the prior bad act witnesses.
Correct. I mean,
is what you're saying.
Yes. I mean, I personally do think that it's important information to know about somebody's character and their pattern. However, I still think that based on what we presented and also the corroborating witnesses and all of that, there was a lot of evidence presented. And so I still believe that it would stand on its own. Yes.
Okay. Thank you. Eric Ortiz with NBC News asks, are you worried that yesterday's decision will dissuade other survivors in general from coming forward if they think it's not going to matter anyway in court? All these are good questions. I'll share my view, and then Mimi also, if she wishes to answer, will answer. I am concerned that it will impact the decision of survivors, perhaps, to come forward thinking that it may not matter if they do, because their testimony may not be admissible at trial. In addition, I'm concerned that prosecutors, when they decide and make the difficult decision, shall we take this case to a grand jury or to a preliminary hearing, decide to charge the accused, may feel that it's more difficult without prior bad act witnesses to prove guilt beyond a reasonable doubt, and therefore they may decide not to charge the defendant or seek an indictment from the grand jury at all. And especially in high profile cases against the rich, the famous, the powerful, well connected defendants, they may decide we may not win this case, we may not prevail in our burden of proof to prove it beyond a reasonable doubt, because if we can't have the prior bad act witnesses, we may not prevail. And therefore, we're not going to take that risk and charge the defendant or seek an indictment of the defendant. Then there will be not only no access to justice for the Me Too witnesses, prior bad act witnesses, but in addition for the actual victim of the crime, who, where the crime is within the statute of limitations, that arbitrary time period set by law, different for different crimes, where it could have been prosecuted, would have been prosecuted otherwise. Let's face it, this is not just about law. There's politics in this, because generally prosecutors, that is the elected prosecutor in a county, runs for election or re-election. And they don't want to have a lot of losses on their record that their opponents could point to when the opponents are seeking to be elected to their seat. So that's the political reality that might deter them from filing a charge, even though that's not something that should be taken into consideration legally. But we can't remove politics from this. It could happen. Would you like to add anything to that, Mimi, or go to the next question, which is for you? I can't hear you.
We can go to the next question.
Okay, thank you. The next question is from Nancy Dillon with Rolling Stone. Mimi, could you describe what reservations, if any, you have about testifying again? She knows this is a hard one. So if you would like to answer it, feel free. If not, I'm sure she'll understand.
I mean, no,
yes.
I mean, it's actually, I feel it's an easy one to answer. It's,
okay.
You know, it was a very, very lengthy process. You know, the preparation process was a lot longer than the part that the public see, right? And it involves so much, just re-traumatizing. It was just rehashing and reliving over and over again. And so it was, and especially after so many years, it was re-traumatizing and grueling and exhausting and all the things. And yeah, I don't particularly want to, I mean, I definitely don't actually want to go through that again. But for the sake of, you know, keeping going and doing the right thing, and because it is what happened, I would consider it.
Thank you. The next question is from Jean Mattis from Variety. And Mr. Mattis asks, as you consider whether to testify again, can you say what factors would make you want to do it again, and what factors would make you reluctant?
Yes, I mean, basically, kind of what I just said. But then, of course, what would make me want to do it again would just be, like I've said in the past, this isn't just about me. It's a really important case. It's in the public eye, which is is uh, is difficult for me personally, but is important for the collective. And so those are the reasons that I would still do it again. It's I'm not just doing it for myself.
Thank you. Next question is from Carolyn Graham from the UK Mail on Sunday. How did you feel emotionally, Mimi, when you heard the news yesterday? And what was your first thought?
I mean, I felt sick to my stomach and my heart sank. But you know, there's a lot in the world that's happening right now that's making me feel sick to my stomach. So it was just another kind of insane feeling day when you can't believe it's real. And so, um, yeah, that's how I felt.
Thank you. The next question is from Katie Butler. Uh, the question is, well, I think this is probably for me, but it says, do you think that the rules of evidence are stacked against female rape victims? Why is this different from non-sexual assault, especially acquaintance cases? How could this be addressed without compromising the rights of defendants? This is it's a very profound question. Uh, in general, I would say that the treatment of female rape victims, often in rape cases, is different from non-sexual assault cases. Uh, I think there are quite a few rape myths and stereotypes about rape victims. And I think there should be, in many cases, perhaps jury instructions in reference to what a court could consider in terms of what rape victims are asked or should not be permitted to be asked, questions that might be objectionable and that objection should be sustained to. For example, that the objections may not be sustained. I could probably be doing a long article about that, but I will say in general that I find in many cases uh, it is important to have an expert testify to educate the jury about many stereotypes about rape victims that we wouldn't find about non-rape victims. For example, if a man is walking in a dark alley at night and then he is robbed of his wallet, ordinarily he will not be asked, why were you walking through that dark alley at night, or what were you wearing that would have caused someone to think that you would like your wallet stolen. But and for a rape victim, often they're asked, like, why did you stay and see him? Why did you see him again? All right. Why did you continue to communicate with him? Which is something the victim in the Bill Cosby case was asked, why did you communicate? Look at all these phone calls. Well, she was able to explain why, because it was her job to communicate. because she was with Temple University at the time. But, you know, why did Mimi ever see him again, communicate with him again? We're not going to answer that question now. But if, as and when she testifies again and asks that, she'll ask it. But I'm saying sometimes that is a question that is often asked of victims of sex crimes. The next question is for you. Shall I move to it, Mimi?
Sure.
Okay, sure. It's from Patrick Eaton Robb, Associated Press. Pat says, Ms. Haley, can you tell us what are the factors you are weighing when considering whether or not to testify again? You can answer it or not answer it. That's up to you.
I think I kind of already answered it. If I'm, yeah, no.
Okay. All right, that's fine. Uh, now there are a couple more questions from Jen Ransom for Mimi. What, if any, concerns do you have about participating in a new trial? As someone who covered the first one, it was certainly a lot for you and the other survivors to go through emotionally. So again, her question is what, if any, concerns do you have about participating in a new trial?
Yeah, that's basically the same thing.
Okay.
It's
All
just
right.
going over it again and going, reliving it a third time, basically.
Okay.
Yeah.
Harriet Alexander from the Times of London has a question for you, Mimi. Have you spoken to any of the women who went through the New York trial with you? And if so, have they discussed a retrial with you? Are they encouraging you to go ahead or avoiding any pressure and saying it's entirely up to you?
I have been in touch, but not really about that. We have been in touch just, this only happened yesterday. So it's a lot to process for, I think, everyone involved. And so we haven't really touched upon that apart from, I did speak briefly about it with
You don't
Jessica.
have to say. Okay, you
Yeah.
did. All right.
Yeah, yeah.
Okay.
Well, I just said it, but
All right.
very briefly, and we're basically just processing still
Okay. Thank you.
the news.
All right. Next question. And this question is from Sharon Knoll with the Rep. And I guess it appears to be for me. It says, do you foresee any other convictions being overturned due to this ruling? Does it set a precedent?
Mm.
Well, it does for New York. But again, the New York Court of Appeals is the highest court in New York. But their decisions are precedent for New York. They're not precedent, for example, for California. So each state, if there is a state prosecution, is bound by the rules of that state. Now, there may be federal issues as well, but it's not binding precedent for another state. I do see this decision of the majority, it was a 4-3, 3 being in the dissent, as being very protective of the defendant, and which is why I say I agree as a civil rights attorney, although I'm not a criminal defense attorney, that an accused person, a defendant, should be entitled to a fair trial. But what about the victims? Aren't they entitled to a fair trial too? What about the people of the state of New York who are represented by the prosecutor who alleges that criminal statutes, the laws of New York, were violated by the defendant? Don't the people have a right to a fair trial in a criminal case? In this case, I think that question is actually more important than the answer. But it is also a point that is made by one of the dissenters who felt that there appears to be a trend of reversing jury verdicts. And I saw that one of the jurors in this Weinstein case was very disturbed that the jury's decision to convict was reversed. And she felt that, or at least she said, that she felt that the testimony of the Molyneux witnesses, prior bad act witnesses, really was not very much of a factor at all in the decision to convict Mr. Weinstein. So if it wasn't much, that's not a quote, but it's a paraphrasing of the juror who appeared on Good Morning America this morning. And I can see why she would be disturbed. Another question is, am I also representing Jessica Mann? And no, I'm not representing her. And he was convicted of third-degree rape of Jessica in New York and sentenced to 3 years of the 23 years sentence. Mr. Weinstein was for the third-degree rape of Jessica Mann. There's another question from Dorchen Leidholt. Do you think that New York State should amend its evidentiary rules to permit prior sexual abuse evidence in sexual assault prosecutions? There is a bill pending in the New York State legislature that would do just that. I have not seen that bill. I'm not disputing that it exists. And I do think that that should be permitted, prior sexual abuse evidence in sexual assault prosecutions, but I would want to review the bill before I fully support and endorse it. I do think that this reversal does cry out for a review of how can we better protect and afford victims' rights in criminal cases in New York. And as I indicated in my statement, I have some thoughts about that. I am also licensed in practice in New York as well as California, and definitely I'm interested in speaking to the legislative committee of the Women's Caucus of the New York City Bar, of which I'm a member, about ideas about how we can move forward to protect victims' rights. The next question is Casey, and this is for you, Mimi. Casey Baker at People Magazine. Thank you for speaking to us, Mimi. You talked about this a little bit, but when you learned the conviction had been overturned, what else were you feeling? Did you think all of this was behind you for good? How do you feel knowing that you might have to relive so much of what you've gone through before?
Yes, I wasn't, I mean, I knew that there was a chance that this might happen, but I honestly thought it was a very small chance, only because in New York, the kind of I heard that it's only about 4% of convictions are overturned. So therefore, I thought it was a pretty small chance, but I always knew that obviously there was this chance, and I definitely hoped that it would be behind me at this point. Yeah.
Thank you. The next question is from Elizabeth Wagmeister of CNN. With this conviction being overturned and Harvey Weinstein also appealing his California conviction, are you concerned that there could be a day, Mimi, when Harvey Weinstein walks free after being convicted in 2 jurisdictions. Mimi, is that a scenario you had ever considered possible after the verdict in 2020?
It's always a possibility. I mean, there's a lot of things that seem unlikely that happen. So it could be. Yeah.
Okay. All of this, by the way, also underlines, from my point of view, the importance of the California prosecution and the California criminal case, which some people previously thought was unnecessary because there already had been a conviction in the criminal case, 2 convictions in New York. Why proceed in California? But of course, in the California case, there was an allegation of violation of criminal laws. And that is not, and also some victims were assaulted, allegedly, in California, not New York, and therefore any jurisdiction to file charges against Mr. Weinstein would have to take place in California, not in New York. I have another client who testified as a Molyneux witness in the criminal case involving Mr. Weinstein in New York. And then she also testified in California. But the difference was in California, there was charges. He was indicted for what she alleged he did to her in California. So it turned out to be a very important decision to file and proceed with the case in California. All right. There is another question from Patrick Eaton Robb, Associated Press. Ms. Allred, have you been contacted by New York's governor or lawmakers about drafting legislation to address the problem? The governor's comments today, quote, I don't want this to be a moment of stifling the environment that was created where finally we were calling out people who were abusing women in their presence, end quote. Quote, we don't want to have any setbacks where there's this sense that you now have to be silenced, and that's something we have to protect, end quote. In answer to your question, it's only been a little bit more than 24 hours, and I don't believe that I have been contacted. I did receive a torrent of emails. I couldn't answer all of them from many people yesterday, and on top of which I was in mediation until all day and into the evening while this was happening. So no, I have not been contacted by the New York's governor or lawmakers in New York yet, but I would welcome such a contact. And most of you on the call here know me, and that is I don't wait for an invitation to share thoughts about how to improve the condition, the status, and the rights of women and victims. I already began to think about that yesterday and have offered some thoughts today, but those thoughts are not limited to what I said. I'm open to new ideas. And I do think that this problem of the reversal is also an opportunity to think about how we can win change, fight for change, as we did in many other cases in New York I was involved in the Adult Survivors Act, and advocating for that change, and without going through all of that, and other acts involving child sexual abuse and so forth. So yes, I'm looking forward to being contacted, but even if I'm not, I may contact them. Thank you for that question. And I am very happy about what the governor Governor Hochul has indicated in the quote that you provided, and I think that's important. Okay, I think we could take maybe two more questions, and that will be it. Um, there's another one from Jan Ransom, and Jan says, "I'm sorry to hammer at this, but Mimi, you said you would quote consider end quote testifying again. It sounds like you are unsure. Is there a chance that you would not testify again? Should there be a new trial? What in this moment makes you say you would quote consider end quote it, as opposed to saying that you absolutely would?" If you wish
So
to answer.
yeah. Thank you. So literally because, this is quite new news. I mean, it only happened yesterday, and I feel like I've just been kind of processing it, and I think we're all in a bit of shock. And like I said, it was, and I don't think people realize. I don't think people know. I mean, people really don't know what I had to go through and what the other women had to go through in preparation for this, and all the fears surrounding it, and all the different things. It's like insane. Like it's grueling. It's hard. It's you're living in fear for years. This whole process took years. And then you're getting harassed. Like I was harassed. I mean, there's so much stuff that people don't see that I had to live with. And yeah, like I have to take a minute to think about it.
And you
But
get to take more than a minute
right.
because there are many,
um,
many factors to consider. And I
exactly.
think there'll
There's a
be
lot of
another opportunity to think about, to talk in the future about what some of
yeah,
those factors are.
yeah. So I think that's what it is. And yeah, I wish it was as easy as going, sure, I'm going to do it again. But it's like, wow, you have no idea what
We
it
have
takes.
one last question, but I think you've answered it. So, um, but uh, and that is from Hugo Daniel from Sunday Times of London about whether other victims have been in touch with you. I think you've answered that, so I would move on. And sorry about that. Okay, I'll take one more. Paul Dorenzo. Uh, what about defense lawyers who say that this decision is good because it limits prosecutors and judges' ability to raise uncharged incidents? Well, I, all I can say is that obviously was an issue for the New York Court of Appeals, and there was a split on the court, but the majority, of course, prevailed, and that was four justices. I think that's not an unexpected position by defense lawyers. Uh, as a victims' rights lawyer myself, as I've said, I know the defense lawyers think that uncharged incidents might prejudice the jury, do prejudice the jury. There shouldn't be testimony about them. But as a victims' rights attorney, I would respectfully differ from them on that, because I do think that is relevant on the issue of motive, opportunity, scheme, uh, and so forth. But again, all of this is always within the discretion of the court. Uh, anyway, we have to thank everyone. We need to log off right now. Thank you very much for attending
Thank
today.
you.
We appreciate it. Thank you, Mimi.
Thank you, Gloria.
And
Thank you,
I
everyone.
we're looking forward to more justice for victims in the future. Have a great weekend, everybody. Thank you. Bye
Thanks.
bye.